welcome to the Sisters for Fitness Wellness Show. I'm Stephanie Gaines-Bryant. Our guest today is Darlene Wright Powell, and she's an attorney. Today we're going to be talking about a subject that affects a lot of women and a lot of men as well, a lot of couples. We're going to talk about child support. Welcome.
Thank you, Stephanie. It's my pleasure to be here.
So, there are a lot of people who are paying child support out here. There are a lot of people who are receiving child support out here. At what point, after you've had the child and you and your partner are no longer together, whether you were married or whether you were living together, at what point can you file for child support?
As soon as you and the other party separate, you can file for child support. If you're residing in the same household together, you can't file because the presumption is if both parties are residing in the same household, then they're both generally taking care of and supporting the child. But once either you move out or the other party moves out, you can immediately file for child support in Maryland.
If you were in a situation where you and your significant other never married and now you're separated, what information do you need to move forward?
You need a current address, and it would be helpful if you have any information regarding their employment history. Because if the other party is not cooperative, you may need to subpoena certain records from the employer and so forth during the court process.
What about paternity? Is it important that you get that squared away immediately as well?
Okay, in Maryland, if the father's name is on the birth certificate, then he's deemed to have admitted to paternity, because when he signs that birth certificate in the hospital, there's language on there that indicates that they understand that this is an admission of paternity, they have the right to a DNA test and so forth. And if they knowingly sign the forms, then they're deemed to be the father. If the father does not sign the forms in the hospital, then he's not going to be on the birth certificate. And therefore, when you file your complaint for child support, you should also ask the court to establish paternity.
Have you ever seen situations where the person signed the birth certificate and it's later discovered that that person is not in fact the father? Do you have any rights at that point, or are you just kind of stuck with it?
Under Maryland law, it really depends on what the situation is in terms of whether or not the court's willing to allow the DNA test at that point. For example, if a child is born during a marriage and it's determined 15 years later that someone else might be the father of the child, in that scenario, the court may possibly say, well, wait a minute, this child has, been raised by this married couple their entire life. This is the only father he or she knows. Now, at, this late date, someone's coming forth requesting a paternity test. They may say, well, we're not going to allow it in this particular situation. However, if you had another situation where, for example, someone was involved in multiple relationships and it's determined a few years after the fact that it is someone else's child, you would have a better chance in that fact pattern in terms of having a new DNA test done and having a new person be determined to be the father.
How is child support calculated? What is it based on?
In Maryland, you look at the mother's income, you look at the father's income. In terms of income, you look at gross income before taxes. You also look at the health insurance, who's paying the health insurance for the child. There's an adjustment made in the guidelines for that. You look at whether there are any things that need to be added in, such as daycare, work-related daycare expenses. That gets factored into the guidelines as well. If a child has special educational needs, those expenses may be factored in as well. And if there are any extraordinary medical needs of the child, essentially expensive medical needs on an ongoing basis. For example, the child's in therapy. We know that every month the therapy is going to cost $500 a month. That's not going to be covered by the existing health insurance. That's an extraordinary medical expense that typically would be factored into the guidelines. And then based on all of the different numbers, there's computer software that the courts run to look at, well, based on these numbers, what would the projected child support guideline be? Now, the software that they use is in accordance with the Maryland law. You can go to the annotated Code of Maryland and you can see, based on this combined income, this is what the guideline amount would be, these are the adjustments you make, but the computer software makes it a lot easier for the court to figure out exactly, what the amount should be.
I've heard so many people over the years, the people who are paying child support saying it's unfair, the people who are receiving child support saying it's unfair, I'm paying too much, I've got this bill, that bill, the other bill, and this is not fair.
Right. Well, in my experience, people who are receiving child support feel they're not receiving enough. People who are paying it feel they're paying too much. When the Maryland legislature redid the child support guidelines a number of years ago, they were presumably looking at fairness. We're looking at gross incomes. If you elect to spend $5,000 a month on car payments, we're not going to have you pay less child support because all of your money, is going to Mercedes or Lexus. We're going to look at your gross income before taxes. And so the whole concept behind the guidelines is to come up with some sort of a uniform, fair process where we're looking at people's gross income.
You just mentioned medical situations. What if after the child support is calculated, the parent has been paying this for a number of years, and there's some unexpected medical crisis that is threatening to just devastate the other parent rather? Do you go back in and recalculate?
Whenever there's a substantial change in circumstances, you can request a modification of child support. I mean, there are a lot of things that could be a substantial change in circumstances. Someone could lose a job. It could be a situation like you indicated where there's this extraordinary medical expense that didn't exist before. Or a child who was in daycare is no longer in daycare because they're now older. So if you go back into court, you'd file for a modification based on a substantial change in circumstances. And then when the court recalculates the child support, if there is a significant difference, they'll adjust upwards or downward. So first they have to find there's been a substantial change in circumstances, and then they can adjust. If they recalculate and there's only going to be a 5% or a 10% difference in child support, then typically that's not considered to be substantial enough, and so there's not going to be an adjustment. But if it's like a 25% or 30% difference in the child support, then typically the court will adjust the child support.
What happens if you have a difficult time locating the parent who is supposed to be paying child support? Is there anything that you can do to find this person? Or is it up to the person seeking the child support to find this person?
I mean, it's pretty much on the person seeking the child support to locate the other party. For example, in Maryland, you need that other party's income in order to calculate the child support. So not only do you need to get them served to put them on notice, you also need their income to calculate it. And even if you could go through an alternative service method, to get the case before the court, how are you going to prove, what the income is?
How about people who have lost their job? Are there people who quit their job as soon as the new job is discovered? They'll go from job to job to job.
Well, there are a lot of people who go from job to job because that's just their pattern, and it's always been their pattern. But there's what's called voluntary impoverishment in Maryland. So if someone is able to work, but they just elect not to work, the court could find that they voluntarily impoverished themselves, and they could calculate child support based on what income they could be earning. So if someone is, say, making $50,000 a year and they decide to quit their job because they want to stay home with their 5-year-old, well, they voluntarily impoverished themselves in that situation. Yes, they can elect to be a stay-at-home mom, but if the child is 5 years old, the court's not going to penalize the non-custodial parent and make them pay more child support because of that. They're going to say, well, this is what the stay-at-home mom was making prior to the time that she quit her job. Therefore, we're going to impute that as being income.
What about people who are on disability? Do they have to pay child support?
My experience locally has been that typically the courts are willing to look at the derivative benefit that they receive for the child. So a lot of people on disabilities, especially if it's like Social Security disability, there's some additional amount that goes directly to the child. And depending on that amount, I've seen a lot of judges who have been willing to accept that amount as support, particularly when the disability income is very low.
What if you've got families that you've got a person who has children by different fathers? Each father has to, it's calculated differently for each father, or how does that work?
Well, the combined income of the parties is probably going to be different. So if there are 3 different fathers, they're probably going to have 3 different incomes. So the combined income of the parties is going to be different in each case. The expenses.
Wait, so you combine the incomes of all of the fathers? Let's just say you have a situation where there are 3 different fathers involved.
No, you do each one separately.
Okay.
So it's father number 1, you look at mom's income, dad's income, what's the combined income to determine the basic child support obligation. Father number 2, look at mom's income, father number 2's income. So in each scenario, each of those fathers is probably earning a different amount of money. So each scenario, the combined income is going to be different. So the guidelines for each child are probably going to be different. Yeah, and then also, if, say, these 3 fathers, if some of them have other children that they have court-ordered child support for, they're entitled to an adjustment off of the gross income. So if their gross income is $5,000 a month and they have a child support order where they're paying $600 a month for a child, and that's a court order and they're paying it, they adjust that off of the gross income. So instead of the gross income being $5,000 a month, it's considered to be $4,400 a month for purposes of calculating the child support.
But you don't take away that, you don't reduce that $600 from that one child to give to the other children.
You reduce it from the gross income. So the father has a lower income in that scenario. So the guidelines may be a little bit lower because his income is a little bit lower.
What if you have a step parenting situation where you have a couple, they divorce, but for 10 years he helped raise the other children? When that time comes for child support, for custody, stuff like that, does he pay for the children who are not biologically his or hers?
Not unless he adopted the child.
Okay. Okay. And that's across the board?
In Maryland.
Okay.
Right.
How about if you've got a situation where the couple is co-parenting, where the father has the child for a particular amount of time and the mother has the child for a particular amount of time? Is there a child support, should they have a child support order in that case? And how is that handled? How is that handled?
It depends on the number of overnights. So in that scenario, if the child's living primarily with mom and dad has a certain number of overnights, you look at how many overnights in a year does he have. You know, if he's kind of doing like every other weekend, okay, maybe he has about 100 overnights or so during the course of the year. That's not going to change anything with the child support formula. If he hits 128 overnights during the course of the year, then the amount of child support starts to go down depending on the specific number of overnights. Because the thought is if the other parent has the child a significant number of overnights, then they're probably incurring more cost in terms of food and transportation, utilities, things like that related to having the child with them those overnights. But again, the key is overnights. It doesn't matter how many days a week you see the child, you look at how many overnights the child is actually sleeping at that other home during the course of a year.
Do you have people trying to rack up those overnights?
Absolutely. I mean, people who have never thought about filing for custody before, once they get served with child support papers, all of a sudden custody becomes important, to them because they're trying to hit that 128 overnights or more.
Is it best for the couples when you have these situations or have situations after the child support order has been made? Is it best to work those situations out between the two of you without getting a lawyer involved, without getting the courts involved? Or is that does that weaken your case if the situation doesn't work out and you do end up going to court? Is it best?
It doesn't weaken your case, but typically you can't go back. So if you've tried, well, it doesn't weaken your case. Like, the court's not going to look at it negatively that you tried to work it out. However, in terms of the court having jurisdiction, in Maryland, the court can't go back before the date you filed. So, like, for example, if it was an initial child support case and you were trying to work things out during the first 2 years of the child's life and then you couldn't work it out, well, then you could file for child support, but they could only make it retroactive to the date that you filed it. They can't go back over those 2 years. Same thing with a modification. If you're trying to work out some sort of a change and you just can't work it out, when you go into court, the court can't go back before the date that you filed.
And I'm sure, as we discussed a little bit earlier, things like medical expenses. If something comes up and Jeffrey needs braces, and the other parent says, okay, I'll go in with you for half of these braces or whatever, but when the time comes, his new wife says, no, you're not going to pay all that.
Right, and in that situation, I would recommend that you then immediately file and say there's been a substantial change in circumstances, child now needs braces, we have this extraordinary medical expense, we want you to recalculate and factor this cost in.
How do you, and I'm sure in dealing with all the things you deal with custody and child support, what is the best way to get what you're entitled to, yet be civil at the same time? You want to make sure the child support is fair and all these things, and our co-parenting is fair, but you want to get along with this person. You don't want an adverse relationship because of money.
Well, a lot depends on the couple. I mean, a lot of people automatically, have an adverse stance once you're asking the court to order them to pay money. And I mean, there's nothing you can do about it. You can try being civil on your end, but you can't make the other person be happy about it or behave in a civil manner. I mean, what I've found a lot is that the non-custodial parent, well, first they'll try to be nice and get the custodial parent to agree to an amount. That amount, when they speak with a lawyer, they'll typically find out that amount is like totally below the guidelines. And then when they don't want to go for that amount, the other party will try to exert pressure. And then when that doesn't work, then everybody ends up in court.
What about back child support? What happens when the parent may be paying for a significant period of time and they just stop, or they start kind of chipping down, they're not paying as much as they should, and it starts adding up?
In Maryland, that arrearage is going to continue to grow. When it gets to a certain point, you probably want to file a petition for contempt and get the other person into court, show that they're knowingly in contempt of the court order, and ask the court to order some strong relief. Typically, when I file a petition for contempt, I ask for jail time. Now, I mean, in Maryland, there's not a debtor's prison, so you can't imprison someone because they don't have the money. But, I mean, if someone obviously has access to X thousands of dollars and they just don't feel like paying it, I mean, a judge could elect to, okay, well, we're going to hold you until you essentially, put up money equivalent to whatever the court determines they can come up with. And the times, it's not done often in Maryland, but the times where I've had a judge say, okay, well, we're going to take you into custody, usually by the end of the day, we find out that they've come up with the money. And then that money, of course, would go to the child support.
What are some of the other penalties that if they are not taken into custody, what are some of the other things that you can do?
Their driver's license can be suspended. If they have a professional license, that could be suspended as well. Their request for a passport could be denied. Their tax returns could be intercepted.
Is that something that happens often too, that their tax returns, you think you're getting this big check?
Yep. Happens all the time. It's funny, I've heard people say, well, I'm not going to file my tax returns because they're going to take the money. It's like, okay, if that's what you want, that's not the solution.
And so is this an automatic garnishment with child support? Does it automatically come out of the check, or how does that work?
Okay, so in Maryland, if the person receiving child support wants it taken out of the check via wage lien, then that's how it's going to be set up. Some people agree once the support is ordered, you can just pay me directly. I'm good with that as long as you don't miss any payments. But they reserve the right to come back into court and ask for a wage,
so there's
an garnishment. Correct. The choice is the person receiving the money makes the choice. So they're entitled to a wage lien unless they agree not to have a wage lien. And in some situations, it may not be practical. For example, if the other party is self-employed, it might not be practical to have a wage lien. But when there's a wage lien, what will happen is you set up an account with the Office of Child Support Enforcement, and then there's paperwork that's signed by the court that will go to the employer, and it will direct them to withhold that money, from the paycheck and send it to the Office of Child Support Enforcement, just like any other type of wage garnishment.
So once, for example, if you're behind on child support, is there a time period? Let's just say this guy's been behind, or this person. I keep saying guys because they're women and men.
Absolutely.
Yeah, this person is behind on child support. Once that child turns 18, is that, I don't even know what the legal term is. Is that done? The person doesn't have to pay?
No, they still, there are people, I've seen people who are paying on cases like 10, 20 years after the fact. They still owe that money. They still owe it, so it doesn't go away once the person becomes an adult. Correct. And then also in Maryland, you pay child support until the child is 18, but if the child is still in high school, then it's 19 or high school graduation, whichever comes first. Can you go back and get that age extended? Let's just say you have a child who goes to college. If that child finishes high school at 18 and doesn't finish college until 22, how is that handled? In Maryland, you're not going to be able to extend it because of college. Now, if you have an adult disabled child, well, then that's another situation where you may be able to get support for that adult disabled child who's unable to be self-supporting and so forth. But in terms of college, unfortunately, there's no requirement that anyone, provide any support for college purposes. If you are married and divorced and have a custody order, is that different in that case? Can you extend that? If it's not a situation where, you were married to this person and custody has been established or whatever, but that child becomes an adult and you want you want your spouse to help, or your former spouse to help with the education. Well, I've done a number of voluntary separation and property settlement agreements over the years where we've put language in there where the parents have agreed to share the college expenses. And we may put in there it's 50-50 or it's in proportion to their incomes. And if it's in a separation and property settlement agreement, and that agreement's incorporated into the divorce decree, well, then they're contractually bound to make those payments later.
But otherwise, 18 is...
Or unless they're still in high school, then 19 or high school graduation, whichever comes first.
Okay, but so custody in Maryland only goes up to that 18.
Custody goes up to...
I mean, not custody, I meant child support.
Right, custody would go up to 18, but the child support goes a little further if they're still in high school, the 19 or high school graduation. So it's 18 unless the child is still in 12th grade when they're 18 or still in high school when they're 18. If they're still in high school when they're 18, then it's 19 or high school graduation, whichever comes first.
What about
That's when the child support ends. But for custody, it's 18.
What about an emancipated child? Mm-hmm. What happens in that case?
I'll tell you, to be quite honest, I've never had that situation occur because most situations where the child is, seeking to be emancipated, they aren't able to be self-supporting. I mean, usually that child, but I mean, arguably, if the child is self-supporting, if somehow they could get into the military or something like that, when they weren't quite 18, then, I mean, that may have an effect.
If the custody situation changes, for example, the child turns 15 or 16 and mom says, I think you need to go live with your dad, and the custody situation changes, it has to go, they have to go back in and recalculate?
You have to go back into court because you're going to have to terminate the child support that's currently being paid and then establish child support against the other parent.
And in that situation, because I've seen situations where the court or the person continued receiving child support and the child is no longer in their custody, do they have to pay that money back? How does that work?
I mean, unfortunately, most judges that I've encountered kind of look at it from the standpoint, well, it was for the benefit of the child, we're not going to worry about it. It was a few months. I've also seen occasionally when it's, you're able to set it up so that child support will hold it in escrow. But basically, as soon as there's going to be that change, you need to file to terminate that child support right away.
Because you will find yourself, it gets complicated.
Exactly, exactly.
If you don't. I also want to let everybody know that we're going to put your web information at the end of the show. You've got a lot of good information on your website, those frequently asked questions, those things that people need to know, from what forms to fill out you've got a lot of good information on your website that people need to take a look at if they're moving in that direction.
Okay, thank you.
We've been talking to Darlene Wright Powell from the law office of Darlene Wright Powell. She's an attorney. We've been talking about child support and those questions that you may have. I hope we answered most of them.
Okay, it's my pleasure.
You've been watching the Sisters for Fitness Wellness Show. I'm Stephanie Gaines-Bryant. Have a great day.